Good evening, everyone. On behalf of Oriental College of ATAL, it gives me immense pleasure to warmly welcome all the participants in day 4 of 1 week online faculty development program on artificial intelligence leading to academic excellence, transforming academic writing and research. Dr. Rovin Tiwari is the founder and director of Research Tech India Private Limited. He holds a PhD in Electronics and Communication Engineering from Amity University, Gwalior, along with a master's in digital communication and bachelor's degree in EC engineering from RGPV Bhopal. He has over 15 years of teaching and research experience with research interest in artificial intelligence, machine learning, deep learning, antenna design, digital signal processing, Internet of Things, VLSI, solar energy systems. He is a reviewer for several reputed international journals and conferences and has published more than 50 research papers. Dr. Tiwari has received the Young Researchers Award in 2022 and Dr. APJ Abdul Kalam Excellence Award 2024. He holds 18 Indian patents, 30 Indian design patents, 8 UK design patents, and 2 Australian design patents. He has authored 3 books and actively provides research, patent, IPR guidance, and startup facilitation to scholars, faculty, and institutions. Today, he will provide a session to us on intellectual property rights and redefining innovation and ownership in the era of AI. Welcome, sir.
Thank you, sir, for the nice introduction. So, shall we start the
Yes,
PPT?
sir. We can start, sir.
Okay. Okay, so very good evening to all of you. I hope the PPT is visible and I am audible to all of you. Okay. Okay, so the today's session topic is intellectual property in the age of AI, redefining innovation and the ownership. So I think all we are from the academic background, academic profile. So nowadays the intellectual property, the patent, it's a very common word for all of us. Nowadays the academic performance indicator and the target key, we have to do the 2-3 patents in a session or in the year. So it is very common and very useful concept and the topic for us. So a part of the intellectual property, we are discussion through the concept of AI. So the word of AI, that is the artificial intelligence. See, so we already aware about the AI. So AI is just not the chat GPT, it was beyond on the chat GPT. AI is the so many of the things. Today we will discuss how the AI can use in the intellectual property, how the AI can use in the innovation ownership startup. These are some points which we will cover in the today's session. So we will start from the introduction to the AI and its transformative impact. Another thing is intellectual property rights. So basically we will discuss on the patents, copyrights, and the trademarks. And these are some more further points which is related to our AI and related to the intellectual property. Like can AI be an inventor? That is yes or no. So can we file any draft or any design which is generated from the AI? Can the AI based invention is patentable or it may be rejected also? What's the clause of WIPO, USPTO? This is the international patent basically, and the Indian IP law. What the Indian IP law says, how we file in the international patent applications, and how we can balance the innovation and regulation with considering the AI, because we cannot avoid the AI, we cannot avoid the content and the images which is generated through the AI. And at last, what's some suggestions, some roadmap for the future AI-driven IPR framework. So we start from the basic of the AI. So basically we know about the AI. What is the AI? So AI is the artificial intelligence. The artificial intelligence which enable the machine to learn, think, and make decisions like the humans. Like ChatGPT is a very common example of the AI. which we know it is a generative AI. Generative AI, that means it generates the something, it generates the content, it generates the images as well as. So what is basically AI? AI do machine smarter. Before the AI, already there are the automation industries. Industry 3.0, 4.0 is already going on. So many of the inventions, so many of the automation is already going on. So what's the AI do? So AI make the smarter of that machine, so that that machine can also think, take decisions like the humans. AI has shifted the innovation from manual experiment to data-driven intelligence. Like before the AI, if we want to analyze the big data, if we have the 1 lakh, 2 lakh of the data and we want to analyze, so there are some software, but they analyze with very less efficiency. But while we are using the AI, the data analysis work is very fast, and the data analysis is the very key part of any of the innovations, any of the markets. Like just like Flipkart, there are the Amazons. So how many people are searching product in the Flipkart and the Amazon? There are the crore peoples, crore number of the peoples which they daily searching the product in the Amazon and the Flipkart. So what's the AI role here? So AI identify the interest and the searching result of the people, and so the similar results and similar things in the different devices. Like if you search in the WhatsApp, if you search in the mobile, so the same product is shown in your system also, because there are the Gmail and the account login. So AI detected, and wherever you will search, it will show the result. So traditional innovation dependent only the human efforts, while AI enable human machine collaboration. So currently, we are not saying that currently all the things are doing by the AI. So there are definitely human is also there. So the relation of the AI and the relation of the human, there are the new thing. Like everyone has the chat GPT. A very simple example. And if you want to write a research paper, so one person can make a good quality of the paper. One person can create a medium quality of the paper. One person can create the low quality of the paper. So there are the chat GPT, there are the same thing, same technology, but different person create the different thing. That means AI is not able to do the things. Human intelligence is also there. How our logic is developing, what's we are thinking on any concept. So based on these two, or we can say there are the hybridization of the human intelligence, human critical mind, and the AI, then the innovation has come out. AI significantly reduces time and cost involved in research and development. So obviously we are using the AI, so we know these things. Like a very simple example, if we want to review any research paper, like there are the IEEE conferences or various conference paper. So if we are reviewing the conference paper manually, so it is time taking, because we have to read out all the paper, we have to check the results, literatures, references, etc. But while we are using the AI, so just copy and paste all the paper in the AI and take some suggestion of the review points. So where we spend the 20-30 minutes to review one paper, here we spend just 1 or 2 minutes for review the paper. So it is reduce the time and cost. Now innovation is becoming faster, scalable, continue due to AI system. Now, usually, so the people who know about the AI, the expert who know about the AI, so the speed of the time, work efficiency is now the 10 time better, 10 time faster. Without the AI, if we want to write an article, so 1 full day, 2 day, or 3 day time taken. But while we use our mind with the AI, so a good article can be easily written by within the single day. So AI help in analyzing large volume of data that humans cannot process efficiently. So obviously the large amount of the data can process only the AI. Humans cannot do this thing in a less time. Now there are the two terms, machine learning and the deep learning. So in the AI, while we're talking about the AI, there are the two technology, two terms, the machine learning and the deep learning. Both technology both technique comes under the AI. There are so many of the other techniques also, but these are the very common techniques, machine learning and the deep learning. So through these techniques, we can do all the work related to the AI, especially for the generative AI. AI is transforming industries such as healthcare, manufacturing, finance, and education. So there are the different examples, and in the different sectors like the healthcare, manufacturing, finance, education, innovations. So AI supports creativity by generating the new ideas, designs, content, and solution. Like if you have, suppose if you have no idea and you want to write articles, you want to write a patent, so simply you can search, give me the 5 or 10 ideas, give me 5 or 10 titles for the utility patent, for the design patent, for the copyright. Initially if you have zero idea, but AI suggests you, okay, these are the 10 titles, and now you apply the critical thinking, which title is suitable for patent or not. Next, many modern innovations are AI assisted rather than the purely human created. So, like currently, whatever the innovation coming in terms of the technology, in terms of the product, in terms of the research, in terms of the academic and industries, so there are now not a purely human created. All the innovations are come with the hybrid of AI and the human intelligence. Now, AI has transformed innovation from a slow human-driven process into a fast, intelligent, and collaborative ecosystem. So, these are the some basics of the AI. What is AI and what AI can do? So now this transformation challenges existing system of ownership, responsibility, and intellectual property. So basically, if you talk about the intellectual property, so before of the AI, if any human can create any new thing, any new devices, new concept, so they do the patent because this is a unique concept of by generated by that person. But nowadays, in a one country now, in suppose in a India, in a Bhopal, in a Madhya Pradesh, the same time in the same time there are the peoples who can generate the same ideas through the AI. So this is now very difficult to claim the actual ideas of which person. Okay, so now we discuss of the intellectual property. These are the some applications which already we discussed in the healthcare, smart manufacturing, autonomous vehicle, creative content generation. Now we come to the intellectual property. So basically, intellectual property, that means the property or ideas which comes from the human mind, human intellect. So because of this is the one kind of innovation, one kind of the product. So that's here the name is the intellectual property, and why we are saying the property also, because like just the physical property, any building, any land, so we can register, we can make a registry of the building and the land for own name. Similarly, if any concept comes in our mind, so we can register, we can secure that concept through the patent. So that's why it is known the property. So basically there are the two types of the property, tangible and intangible. We already discussed tangible like the physical property, and non-tangible, intangible, not measure, it's a intellectual property. Intellectual property is categorized into the basically two parts: industrial property and the copyrights. So the patent, the design, the trademarks, the GI, it's come under the industrial property, because most mainly the patent related work is for the commercial purpose, for the not for the academic purpose. Initially it was not for the academic purpose, it was for the commercial purpose, but nowadays it is commonly used in the academic as well as the commercial purpose. Copyright is basically for if anyone create anything like any image, any picture, drawing, song, clips, videos, poem, article, shairi, anything. So if any person create the anything, and if it is new, then he can protect that thing using the copyright. But if person create anything which is useful for the society, especially for in terms of the technology or in terms of the commercialization, then it's come under the patent, design and trademarks and GI, geographical indicators. Okay, so why the person do the patents, you know, there are the one concept why the person do the patent. So the common person do the patent for the pride ki, okay, I have the 10 patents, I have the 20 patents, so it's for the pride. Another thing is it is for the academics, like in the our academics schemes. Now there are some compulsion and initiative of the government of India also ki every college university have to file the patents, because the patent reflect the innovation of that country. Approximately 2.5 lakh patents in India, and we come into the under top 5 in the world for filing of the patent. So actually patent reflect the innovation of the country, so that's why it's needed to file the patent in the academic and as well as the commercialized person, you know. Next, why the businessman do patent? Because he want to protect on product. If any person make a product which can be commercialized, so businessmen want to protect that product. For the brand value, sometimes you see in the ad ki there are the solar based technology, some technology based the inverter, so there are some of the ads. So patent make the brand value. He This product is already patented, and mostly jo related like pharmacist and related to a pharmacy, there are so many of the continuous invention in the drugs, in the in the medicines, in the vaccines. So they have to do the file the patent before disclosing the drug in the market. Earn and invest, and sometime if a person make a patent on such a new technology which is never come in front of the people around the world, so that is very earning purpose also, we can sell out the our patent, we can give rent on our patent. So like if you are the simple man and you make a technology and you have to file the patent, if you have granted the patent of the patent. So there are the some varieties, like the common word which we say the patents. What is the patents? Patent is basically it's a utility patent or the idea patent. So what is the patent basically? Which is utilization for the social, which is related to the technology, which is related to the new invention. So it's all comes under the patents. Next is design. So design, that means if you make any product, like if you make the laptop, if you make the mobile phone, if you make the new design of chair, new design of car, new design of water bottle, new design of furniture. So if you make any of the design, so here it is not necessary कि the design is based on the technology or not. Design is just design. So if you file any new design, so it's come the design patent. Next, trademarks and the secrets. So trademarks, like if any company make a product and want to sell out the product, so what's the logo which is apply on that product? That is a trademark, like the Apple trademark, Lenovo trademark, any of the trademark. And trade secrets. So trade secrets like the Coca-Cola. Coca-Cola company have a one recipes by which they make the all the Coca-Cola related drinking bottle, cold drink bottles. So it is a trade secrets. Simply in terms of the, it is a recipes to make any product. Next is geographical indication. So geographical indication, that means if any particular land, particular area of any part of the country, and if there are some famous things, like Sihor का जो गेहूं है, it is come under the GI indication. So there are some of the animals, some of the food related things, some of the natural related things. so which comes only in the particular area. So that is patented under the GI. So GI tag recognized by the worldwide, like in India, how many the GI tag. So if any their particular eating product, if any particular species of the animals, is it GI? So it is reflecting just the innovation or the differentiate from the other areas, other worlds. Now copyright, so already we discussed, if any person make any new thing, so it's come under the copyrights. Next, semiconductor integrated circuit layout design. It is the special varieties of the patent because there are the ICs, there are the CMOS chip, VLSI chip. So in the chip there are the circuit designing, and every circuit design layout is different from the different circuits. So basically it is starting owned by the Silicon Valley, and because the large number of amount of the semiconductor design initially was there, but now it's doing India also. So if any person make any noble circuit design, so it's come under the semiconductor integrated circuit layout design. Again, especially for the biomedical related, for the pharma related, where if any person find any new species of the plant or any new varieties of the plant which is useful for the human, in all the patent there are very compulsory point. Every patent, every innovation, every design, every concept, circuit, all the things is useful, only useful for the society. Like if any person make any non-useful thing, non-useful patent, non-useful design, so it will not be patented. So this is one example. Through this we can understand all the varieties of the patent. Like there are the symbol of one laptop, which is the Apple laptop. So if we see only the out view of the laptop, how the laptop is looking, from the top, from the bottom, from the side view, from the left view. So these all the views, when we file these all the views, how the laptop is looking, it's come the design patent. So body of the laptop, how it's looking, it is a design patent. And what technology inside the laptop, how the LED is glowing, how the laptop is on, how the laptop is working. So inside the technical mechanism, it's come under the patent. Now there are the one Apple sign. So this Apple sign come under the trademarks. This is the company logo. Simply in the simple words, company logo. In the patent terms, it is a trademark. User manual. User manual means how to save the laptop, do's and don'ts of the laptop. If there are any issues, so how to resolve that issue. So these come in the one manual. While we purchase a laptop, so there are the user manual. So that user manual can be copyrighted. So this user manual comes under the copyright. And the layout, so this is the layout of IC. Suppose this particular laptop is using one particular processor, and that processor have these kind of the circuitry layout. So it is come under the SICL design. So I hope you understand till here related to the patents, how one example have the different varieties of the patents. So what is the patents? Already we discussed, utility patent. I hope you understand the utility patent. Utility patent is just where any technology, any innovations, which is useful for that society. And if we talk about the validity of the utility patent, so validity of the utility patent is 20 years. 20 years from the filing date. Utility patent grant take time also. Minimum time is approximately the 2 year, and maximum time approximately the 5 year. 5 year is very long time for the utility, but sometime utility grant take the 5 year time. So the validity starts from the date of filing. Suppose today you file one utility patent in 2026, and after the 4 year you have granted the utility patent, but the validity starts from today. From today till the 20 year, and after 20 year you can renew in the next 5 year. Some famous Indian innovations, like the nano car. Nano car is one famous innovation of the India. Hepatitis vaccine, Jaipur food. It is very affordable. Now patent application filing. There are some forms and fees and the timelines. So firstly, if you want to file the patent, and if you want to make a utility patent, so firstly we have to search in the Indian patent database, INPASS. This is one of the authorized Indian government site, ipindiaservices.gov.in. So there are the public search option, and in the public search we can easily search the patent through the given application number. And in the starting Google, or we just go to the ChatGPT and search anything. But patent related things, especially there are the Google patents, patent.google.com. So like if we also want to file any patent, so firstly we have to search in the Google patents. Very simple example, like if we want to make a system to manage the marketing strategies in e-commerce platform. This is the one example. I want to file a patent which is useful in the online digitally marketing campaign, marketing product, e-commerce. So we we enter these keywords in the Google patent, and Google patent give us the number of results, 10, 20, 50, 100 results they can give. So overall we have to find out all the results, and like what's exactly currently the people already filed related to this concept, and how many these concepts are published, and how many these concepts are ongoing for the examination process. So we have to find out, we have to work out. So this process is known as the search report. Usually when we do the patent, so the patent attorney or the patent agent, patent person says, okay, so this is your topic. So firstly, I will give you the search report. So search report, from where we find the search report? We can find the search report from the Google patent. It takes the time, lot of time. Now want to file patent application in India, what to do? So patent application, if you want to file patent application in India, so you can file on, it's not necessary that you can file the patent through any other person. You can file patent your own. You have to make you have to make the account in the IP India site. IP India site, firstly we make the account. Then there are the online forms. We have to file the forms. So there are some important form, like a form 1. Form 1, there are the detail of the application and the applicant, like how many persons are applicant and how many persons are inventors, and what is the title, what is the basic things. So we have to fill the form 1. Form 2. So form 2 is very important, because in the form 2 we have to mention all the detailed descriptions of our patents. So detail of the invention, like the title, background of innovation, particular of drawing, brief description of drawing, brief description of the innovation, claim, abstract, and drawing. So form 2, I show you one form 2 which is already published. So you will get the better idea how the complete specification of the patents. So yeah, this is the form 2. Okay, so this is the form 2 which we have to make, which we have to prepare for the filing purpose. So you can see form 2. This is the common thing which is already written in the forms. Now here we apply the title of the invention. So this is the title of the invention: Smart Business Decision Support System using the predictive analysis and market trends. And then here are the list of applicant inventor. Now the complete specifications. Write a title. Now, whatever the title, this title is related to the management, smart business decision support system using predictive analysis and make trend. So firstly, we have to write the 4 to 5 line for the field of invention. So first 4 to 5 line or the first para represent the field of invention. Next, we have to write the background. So in the background, we have to search in the Google patent, and based on the Google patent results, we have to sum up in the 4 to 5 para to up to the 10 para, which whatever we want. So here we include the 7-8 paras related to the background. So this is the para 1, para 2. Like in the research paper, we write the literature survey. So similar the literature survey, we have to write the backgrounds. So this is the one more para, 5, 6, 7, 7, 8 paras. Next important point is the objective of the innovation. So whatever we are proposing, whatever we are claiming, we have to make the 3-4 objective minimum, minimum 2 objective, maximum 10 objectives we can make. What our particular concept will do. So we make the objective of the innovation. So this is the format of objective of the innovation. Next, we have to write a summary. Summary is again the format of utility draft. So 3, 4, 5 paragraphs, we can write a summary. In the summary, simply summary, we have to write the summary of our innovation. Then brief description of the drawing. So whatever the drawing or the flowchart we have made, so related to that, we have to write 1, 2 para. Then detailed description. So in the detailed description, we have to write here the technical concept, technical description. Well, basically, what's the innovation, what's the new thing we have to mention here. Is smart business decision support system, multi-layer CRM record. So technically concept will come here. Our proposal will come here. 3, 4 para. Now we write the claims. So up to the 10 claims we file, 10, minimum 2 claims and maximum 10 claims. So what we claim key data input module is new, and whatever the CRM concept is new. So just we have to write the claims. Next, abstract. So into 2 to 3 para, we have to write the abstract. And then at last, we have to attach 1 or 2 drawing, minimum 1 drawing, maximum how many number of you can, up to 10 drawings. So minimum 1 drawing. In 1 drawing, 1 figure, we have to show the flow, workflow, data collection, processing, analysis, like that. And then we have to write the description of that block. So basically, this is the complete specification of Form 2. So usually we have to do the patent, we have to write up the utility patent. So this is the basic draft, how the utility patent will look like. So now come in our PPT. Okay, so now the Form 3. So Form 3 for the foreign filing. So we have to, if we are filing in India, so we need only the Form 1, Form 2. Form 5 for the inventorship, Form 18 for the examination, and a utility, actually utility patent do in the 2 steps. One is the utility publication, and another is a utility grant. So for the utility grant, Form 1, Form 2 and Form 9 is sufficient. For the grant, we have to file the Form 18. If you talk about the government fees, so if we file only the patent, so the government fees is only the 1600. When we file the early publication request, then we have to pay extra 2500 more. So overall 4100 receipt when we file the utility patent. And if we proceed our patent for the examination, then extra 4000. So approximately 10,000 is approximately fee if we file the utility grant. And if file the utility grant for the company, for the commercial purpose for the companies, then its fees is a 28,000 approx. So it is a common fees. Fee may increase up to time. Okay, now the filing procedure. So it's a very simple. Firstly, make an account in the IP India. Then submit all the forms. Basic timeline. So these are the basic timeline. Like 12 month for complete specification, 48 months for examination. Okay, 48 months. So that's why the overall process of the patent take 1-2 year to 4-5 years. Fast examination. If any startup, any female candidate, so examination will be fast. Okay, so now this is the overall about the utility patent. Now we talk ki how we AI can use in this utility patent. So okay, first of all, when we talk about the drafting of the patent, drafting of the utility. So before the AI, we have to write the manually. We have to search in the Google patents, and when the Google patent is also not there, so we have to search from the IP India website. IP India website, there are the all the existing patents available. So we have to find out all the existing patent related to our topic only, whatever our topic. So mostly minimum 5-10 to like 10 to 100 files are there related to that topic. So we have to analyze all the 100 files. But now if we talk about AI use, so what AI do? So AI just show your close result. Like if we find the utility patent related to the e-commerce. So if I give the commands to the chat GPT or any of the AI tool, or a part of this one patent Sarthi, which is launched by the government of India. So through IP is also using the AI now. IP IP India is also using the AI toolbox to search the results. So when you go in the IP India, so there are the IP Sarthi. So through the IP Sarthi, we can easily find out the existing patent. So the time taken for the search report initially, that was the 3-4 days to 1 week. Currently, it is taken only the single day, 1 day. And if we talk about the drafting of the patent, so it is also easy, because we take we take the help from the online AI tools, from the chat GPT, Gemini, to write the patent draft. So parts of form, we already discussed. Types of the claim, this is one important question. Types of the claim, there are two types of the claim: method claim and the device claims. That means which method you are proposing. If is your method is new, or is your method is old, is your method is hybrid or any conventional method, so it's come under the method claim. Device claim, like if we make any device using the some utilization, using the some techniques. So like the if we make any product, if we make a mobile phone, if we make a laptop, so which method for working and which method to overall process. So only the specific method. So in the one device patent, there are multiple methods. So multiple methods, individual methods come under the method claim, and overall device working related, how overall device operated, it's come under the device claim. Apart of this, there are two more varieties: independent claim and a dependent claim. So independent claim, like if we are saying ki, the AI is enabled now in the laptop, so this is the independent claim of how the AI is enabled the laptop, how the AI is using in the laptop through the some app, through the some pre-built app or any other facilities. So this is under the dependent claim. Now the popular areas of patent filing. So the patent filing is usually many of the patent filing is usually in the medical field, we can say that the large amount of patent filing is through the medical field, through the pharma companies, which is making the continuous drug, continues making the vaccines. Another filing by the technical persons, like we are the technical person. So in the second number, technical filing is related to blockchain, smart contract, NFT. Then next, some basic AI technology, then the green technology. This is the patent office journal. This is the overview how the IP India sites look like that. This is the one journal page. After publication of the utility patent, the concept is published in the patent journal. So look like type this thing. This is the one certificate of the patent which we did in the 5-6 year ago. So you can see here why I attached this certificate, because you can see the timeline here. You can see the date of filing. So date of filing is a 8th of April 2019, and date of grant. So date of grant is the 24 May of 2024. So it's filed in the 2019 and it's grant in the 2024, approximately 5 year and 1 month time taken by this utility patent. So in India, utility grant is some tough. No, it's not so easy. Utility grant is very tough. Only the 10 to 20% success ratio of the utility grant. So this is one common questions. What protect the advanced disc brake for bike developed by the inventor? If any inventor innovate the disc brake, disc brake in the bike, so how he can protect this concept under the copyright, geographical indication, patent designs, and trademarks? So all the participant, you can give the answer in the chat box. You can write just copyright or the patent or the design. So I hope you, if you understand all the things till here, utility patent, design patent, so you can give the answer easily. So all the participants are requested to give the answer in the chat box, and I will check later. And how long can a patent last? 10 year, 20 year? This thing also we discussed. Utility patent validity is. Now we talk the design patent. Till now we discussed the utility patent. Now we discuss the design patent. So basically, design patent that means the design overview, the design outlook patents, how the device look from the outer surfaces. Like, so these are the design of the sari, design of the fan, design of the machine, design of the bag. So these are the just the design patents. The water bottle, safe configuration, surfaces, design of an articles. So this is a certificate of one of the design patent. So in the design patent, take the 3-4 month time up to the 1 year, or nowadays it is taking some long time up to the 2 year also. So I will show you one of the filing of the design patent. Okay, so this is one of the design file. So you will have the idea to see the design patent. Like, there are one title of the design patent, that is a AI based learning and teaching device. Up here the thing is that if we file only the learning and teaching device, so learning and teaching device, it is a very traditional design. It is a very common design and a common title. If we file only the learning and teaching device, learning and teaching device, so blackboard, chalk, duster, this is the learning and teaching device. But if I add the word AI based learning and teaching device, so we can use the laptop, computers, tab. So this is one of the design we make under this title. So basically in the device design patent, we have to file the 7 different views. And the first view is the prospective view. Prospective is the overall view of the product. Next, we have to submit the front view and how this prospective design looks from the front. So this is the front view. Similarly, from the rear view, front and back. Then the top view, how it's like the top view. It's this thing we study in the ED engineering drawing. In the engineering, top view, front view, back view. So top view, then the bottom view, and the left side view and the right side view. So total there are the 7 view: prospective, then front rear, right left, and top bottom. So how this design patent looks like, we have to file this description, and after the filing there are the examination process. Then the IPR controller or the examiner will ask the question related to how which technology you are using in the AI, and how it is beneficial for what is the difference in the design of this design and the previous design, what is your global concept. So all the things during the examination process in the design patent. Uh, this is the UK design patent, similar the Indian design patent. This is the UK design patent certificate. This is the Australian design patent certificate. Some people ask the question ki Indian design patent is granted or not. So this is very common questions. Most of the time people ask to me. So Indian design is also the granted patent. It is very clear from the IPR side. Indian design certificate, the certificate of registration has the equal rights of the grant patent, because it's have given the validity which is written in the bottom of the patent. There are the 10-year validity of the design patent, and up to the 10-year it is granted for the person who take this certificate. After the 10-year, we can renew also up to the 5-year. Then next 5-year we can renew this design patent. Similar the UK design, its validity is 5 years. In the UK, they mention the grant word. In UK, they mention the grant word, but India and the other countries, they don't use the grant word, but it's a granted patent. Now, what protects the intellectual property created by fashion designer? If any fashion designer, and if he want to secure her design, so in the which category he want to secure the design? It is copyright, geographical, patent, design, trademark. So all the person, all the participants, you can give the answer. It is come under the patent, design, or the copyrights. Now we come the trademarks. So trademark means it is any word, any name, any symbol, or any device, or any combination of any companies. In the simple words, it's a company logo, it's a company punchline, it's a company tagline. That is a trademark. So what's the function importance? Trademark differentiate the company. This is this company trademark, this company trademark. The people easily recognize the companies. Like there are the different banking sign. Like HDFC Bank, PNB Bank, SBI Bank. So if people see the sign only, the logo only, he will easily recognize. Okay, so this is this particular bank. Or if any product, if you know the trademark, if you know the Apple Coca-Cola bottle, so you know easily recognize, okay, so this is the product of this particular company. This is some common trademarks, McDonald's, Coca-Cola, Google, Adidas. This is the very common trademarks. Trademark can be represented by the this type of the alphabet also, like the TM is alphabet, and R is alphabet with circle. So trademark can be like this also. It's not necessary that we have to make a design only. We have to make any alphabet, any combination, but it should be the new. If some person registered the TM trademarks, then another cannot do. So trademark is also initially registered up to the 10 year, and it can be renewed 10 year and indefinite time, up to the many year you can renew up to the 10 year. Okay, so this is some examples of the product view, of the trademark. Here the Britannia is a trademark. This is the packet view, so it's come under the design patent keys, how look like the packet design. So what does a trademark protect? Trademark protect an invention, a work of art, logos, name and brand, a secret formula. So just give the answer in the chat box. What will be the answer of trademark protect? Now we come to the copyrights. If we talk about the AI in trademark, AI in design patents, so how we can do? Like, okay, in the initially when we have to the design of any product, so we have to use the different softwares for that particular design, or we have to do the manually production of the design. But nowadays you can make a design through the AI also, like through the 3D image generated tools hai, there are the 3D image generated tools. So through the 3D image generated tools, we can create the design. But currently there are some dispute, like if you file the AI generated images and you can file for the design patent, so it may be accept or it may be rejected. It's depend on the IPR controller. If he find if any of the design is completely generated from the AI, so he will be the reject. But IPR controller find this design is created by the some AI help, but using the some conventional software also, so it may be accepted. Similarly, trademark, if you talk about a trademark, so if you generate any logo, if you generate any punchline through the AI tools, so it is easily registered. There are no any clause you cannot trademark uh, design or logo generated through the AI. So it is not there. AI generated logos you can register, but AI generated designs you cannot register. It's depend on the controller. Now, what is copyright? So copyright, anything, any work, any music, song, videos, audios, anything which is created by the person can registered under the copyright. There are only the condition for the copyright key. It should be the original. Most of the time, if we file the copyright, if we file any content for the copyright purpose, so the IPR is check the plagiarism also. If it is find the highly plagiarized, so copyright document is rejected. So it's very necessary here कि we file the unplagiarized content, and if you file any images or any music, anything, so it cannot be copied from any other sources. Like for the music sounds, for the video clips, movie clips, only the 30 seconds clip is allowed as it is. Like if there are any existing song and you are make a new song related to that song, so 30 seconds music, 30-second clip you can use as it is, but rest of the thing you have to do the novel. Like Three Idiot controversy, there are the author Chetan Bhagat, his this movie is based on that book. So without the credibility of the Chetan Bhagat, the movie is starting, but later the this matter go in the High Court, Supreme Court, and finally the disputes sort out. So overall, for the this is the understanding for the copyright. So subject matter of copyright: literacy work, dramatic work, sound recording, artistic work, musical, cinematography. It's come under the copyright. This is a certificate of copyright, how the copyright looks like. Okay, so validity, if we talk about the validity, so the validity of the copyright is the 60 year, 60, it is a year validity. And after the 60 year, it is then open to all. Like Mahatma Gandhi written books is openly public for the after the 60 years from the date of creation. So if any person make any of the noble thing, but after the 60 year, like the 60 year before, any music, any video clips, you can use freely. If you want to use any video, any music, so 60 year before, 6 year ago things, 6 year ago things, any of the things, images, drawing, content, stories, you can use freely. Copyright protect up to the 60 year only. Okay, so Mahatma Gandhi books I discussed. So after the 2009, when 60 year is completed, then all the persons use and the concept of book. Okay, now SICLD, semiconductor integrated circuit layout design. It is basically the for the designing only. If any person make the circuit, so he can protect the SICLD. Okay, so I think this is the geographics indications. So this is the GI. It is a geographical indication. Many of the application like the tea of the Darjeeling, the Taj Mahal, and Bastar Dhokra, many of the things, Sihor ka gehu, Nagpur Santra, Nagpuri Santra. So these type of the things, eating things or area related things, now it is comes under the GI. So its GI validity is also initially 20 years and later 20 years. It can also initially 10 years and after 10 years it can renew. So now the basic concept, all the patent, trademarks, GI, copyright is over here. Now we discuss the some common thing, what cannot protected. What cannot protect है ना, what cannot patented, क्या patent नहीं हो सकता. So invention contrary to public order or morality, it cannot be patented. That means in simple words, if any concept, if any things which is anti-social or harmful for the society, it cannot patented. Any new method which is related to agriculture, horticulture, it's also not patented. Invention already disclosed to the public, previous invitation, like I give you 2-3 example which is currently rejected in the patent office, which is filed by us. One of the example, we filed the one design patent that is related to the animal replicant device. Animal replicant device. So the overall purpose of the animal replicant device in the agriculture, we want to apply in the agriculture field, farm field, and the animal replicant there through that device. But the IPR controller says ki, no, if animal if this device is harmful to animal, so this device can harmful to people also. Like if any small child close to that device in the agriculture, so he can also harmful. So that's why he rejected the design patent. Similarly, one of the design patent we filed related to the one part of the drone system, drone system, and the one part of the jets, jets which is used in the military. So again, IPR controller says it is a national security issues, and based on the through the national security issues, he rejected the application. So there are some common mistake, or cannot say ki some understanding. Sometimes they don't understand the things ki what we are saying, or as per the IPR jo norms hai. So according to the IPR norms, many of the time they rejected also. If they find ki na it is harmful for the society, it is harmful for the nation. Now some points to remember ki first protect then publish. So if any person create any new thing, and if he want to publish their article. So it's a good thing to firstly take the patent on that particular innovation, then you can publish. Because if any concept is already published, so you cannot take the grant of that patent. But if you take the grant of patent, then you want to publish, so it is considered. Okay, now, so there are some global innovation index. No, we can skip this point. Already we discussed now the India has a top. India comes in the top 5 for the filing of the patent. State-wise patent filing. So we can see here the Maharashtra filed the more number of patents than Tamil Nadu, then Karnataka, and Madhya Pradesh. So, but now these figures is changing, because I think all these states, all the academic institutes are filing patents continuous. So this is some more list. IITs. Most of the IITs, many of the IITs fast large number of patents. Some private universities also filing the large number of patents in the previous years. Top 10 foreign resident applications. Okay. Okay. So now we come to our next point. So can AI be an inventor? It is legal and ethical dilemmas. So AI cannot be inventor, because AI is not a person. So as per the IPR rules, as per the IPR norms, only any person or any companies can be a patentee. Only a person or only a company can be a patentee. So AI is not a person or AI is not a company. AI is just a technology. So AI is not a legal person. So AI cannot take any patent. Because a robot cannot sign a contract, so it cannot be invented. Patent laws are made for the humans. Because it is for pride, it is for protection of the human intelligence, human intellectual properties. There are one example, because the AI responsibility is still unclear. If AI like if we talk about a driverless car, driverless car is through the AI technology. AI technology ke through driverless car is operating. So if a driverless car hit to any person, so who will be the responsible? A car is responsible, a technology is responsible, or a company who made the driverless car, that is responsible? Who is responsible? So it is currently unclear. In a general, the owner is responsible. That means जो कार जिसने ऑन किया है, who is the owner of car, that he is responsible. Not the technology responsible, not the company is responsible. Human innovations may lose value. If IPR give the priority to the AI, so the human inventors may lose value. So that's why currently in the simple single words, so AI cannot be inventor, only the person or only the companies may be inventor. Now AI generated content and copyright ownership issues. There are so big issues, AI generated content and copyright. So if we make the completely patent draft to the AI, or if we make any complete song, complete clips through the AI, so it's can be registered under patent or it can be registered under copyright. So in a single line, any of the content, any of the design, if generated from the AI, it cannot be patented, but it can be copyrighted. There are the difference. patent cannot be granted, patent cannot be registered in any of the AI content or any of the AI design. है ना? But if you make any new things, drawing, design, voice, sing, song, videos, clips, animation, movies, so it can be copyright. It can be copyrighted, you know. But if you make any technical concept, if you make any technical utilization through the AI, so again it's not be copyrighted. Copyrighted only registered when the AI and the human minds, you know, both will work out, then it is, then it can be registered. Now the next point है कि patentability of AI based invention, है ना. So simple, in the single words, because AI is only the tool, AI is only the tool, so directly AI cannot be registered, है ना. Directly content generated from AI, design generated from AI, it is not patentable. So AI based invention can be patented if AI used as a tool only, you know, and a human plays an important role. If IPR controller find कि human mind is apply and human play an important role, AI is usually only the tool purpose, then it can be patented. AI itself cannot be an inventor, you know. So as per the IPR rules, कि only the person or only the companies can be inventor or the applicants. Human contribution must be shown clearly, you know. Like if you make any animation movie and you want to file under the copyright, so in that case also you have to show the human contribution. Next, pure AI generated invention are not accepted yet, you know? So till date, any of the companies, any of the IPR industries, it is not accepted the purely AI generated invention, you know? Even one of the copyright dispute is still going on in the Supreme Court, you know, where the two applicant which has generated the same concept content and they file for the copyright, and the IPR in the IPR side, the IPR controller find that there are the two same concept which is filed by the two different person on the same date or almost the same time. So it is very tough for the IPR controller ki which person should give the priorities for the registration of the copyright. So they sent this application to the Supreme Court because practically it is not possible ki two different location person file the same content. You know? So it's still under the undergoing hearing in the Supreme Court. If any two person make a AI based data, AI based content, and at the same time, same date, if they file for the copyright purpose, so who will be given this copyrighted? So it's still in the hearing phase. Now there are the international perspective, that is a WIPO, US PTO, and the Indian IP law. So basically, WIPO is what? It's a World Intellectual Property Organization. WIPO basically it is associated with the American firms, American patent firms. So WIPO is a global body under the United Nations. Like Indian patent, Indian utility patent, Indian design patent. Similar, there are the WIPO patent. WIPO recognize and control the overall world patents. Not completely all the countries patent, but most of the countries are registered under the WPO. So it is studying how AI impact IP law worldwide. It's not in the final decision modes, it's the undergoing stages. Now WIPO agrees that current IP laws are human centric and need to update for the AI. One example, WIPO conduct a global discussion on the whether AI generated work should get separated IP rights. So it's there are the talking, can AI related any content concept innovation can be separated Next, USPTO. The USPTO, that is a United States Patent and Trademark Offices. So USPTO, that is a purely United States based patent and trademark office. It is clearly stated that AI cannot be an inventor. AI cannot be an inventor. Only humans can be named in the patent application. AI is treated as a tool, not a creator. Patent application naming AI as inventor were rejected in the USA. So it's the same laws also followed by the Indian IP. Indian IP is also not considered the for an inventor. If AI is an inventor, then it can be rejected. Even as it is, even as per the government rule, government is saying if you generate any image or the video from the AI, so you have to mention this is the AI generated content.
Rovin sir, one of the participants has
Okay.
asked question.
Okay. Okay.
Supposedly,
So
we code an application through AI, like from Chat GPT or Google AI. Can it be copyrighted? And will there be any lawsuit?
yes, if you make any of the content through the Chat GPT, so you can submit for the copyright. But actually nowadays the IPR is checking the plagiarism. So if IPR find it is 100% plagiarized, that 100% content created from the
You
AI.
mean
So most
AI
of
content? AI content, right?
AI content, 100% AI content may be
Yes.
rejected. So it is better that you generate the content from the AI, then you change something manually. So it is not showing the 100% AI generated. 50% it is okay. It can be registered.
Okay, sir. Okay.
Okay, so just 4 5 minutes, then last 10 to 15 minutes, we take the more questions. Okay, so the balancing innovation and the regulation in the age of AI. So now here we discuss the how the innovation and how the AI based innovation can be regulated by the authorities. you know, like the self-driving car. So AI helps car drive automatically. So here the regulation. So the government allow testing but required safety driver and road rules. Also, there are some fixed regulations if any person make damages, like the if any driverless car or if any driverless car make the damages. So there are currently no any fixed rule, who will be the responsible. There are the very different rules. So it should be the government uh, should restrict if any AI based machine make a damages. So who will be the responsible? Either the operator will be the responsible, or the owner will be the responsible, or the company will be the responsible. Like there are the robotic surgery. If any doctor do the robotic surgery through so through the robotic surgery, if any damages to the patient, so who will be the responsible? Doctor will be responsible or instrument will be the responsible. So currently, as per the IPR norms, IPR rule, because the patent given to the person or company only, not to the technology. So responsibility will also come. Responsible will also the person or the companies only, because who take the patent? So this particular person take the patent, or this particular company take the patent. So if any damages, so who is the responsible? So that person will be the responsible. That is this is very clear thing in the law, but in the IPR law, it's currently in the discussion stage. But it should be either the person or company should be the responsible. Now AI recommendation system. AI suggests the videos and movies based on user interest. So there's are also should be some regulation, because the platform must avoid harmful or misleading content. And many of the time, if any content should not be reflected frequently to the underage children, but the recommendation system is already inbuilt. If any child search something, and if parent don't want to see this thing in front of the child in the AI based devices, but AI system show that thing frequently. So there are some regulations in this field also. Facial recognition technology, the AI helps in security and the attendance system. So there are regulations कि some countries restrict its use to protect privacy. Because in the, if you go, if any new places, if any new hotels, if any new venues, and there are the facial recognition system, so facial recognition recognize your face, so when they recognize your face, your data, your face data captured in their system, so after that they can misuse the your face. Many of the times such of the crimes is reported कि if any bad videos is making by some persons, so the accused is say कि no, I never visit that place, but when he see recall कि okay, I visited that place, there are the face recognition system. So based on that system, they recognize the face, and that face they use for the bad videos purpose. So there are also some regulation if any recognition based system is inbuilt there. So after the security check, instantly it will be the deleted. AI in banking and loans, So AI banking and loan, that means AI check the credit risk quickly, credit risk, or we can set the analysis of the data of the customers of the clients which is applying for the loan or anything. So in the AI there are some biased in the AI, it is find the biasness also, it's that means it's not fairness. Like when you chat with the chat GPT and you ask any question to the chat GPT, the chat GPT give answer, and if you say no, this answer is wrong, you the answer is this thing, so instantly chat GPT give also say ki, okay, I am wrong and the new answer is this. But again you say ki, no, this answer is again wrong, give me the right answer, then chat GPT again say okay, I am wrong, give the answer as per your questions. Means simple word, what you want to listen, what you want to suggest to ChatGPT, bias it will not give the bias.
Sir, your net connection is slightly problematic. The
Okay.
voice is breaking. Hello.
Okay, sir. Is this audible?
Now it's audible, sir.
Okay. Okay, so now this is the last point. Future roadmaps for AI-driven IP framework. So recognizing human AI collaboration. So in the future, the currently we are discussing ki IPR give weightage to only human and the companies. It is IPR is not considering the AI, but in the future it may be considered to the AI also. Like the AI may also become the applicant, AI may also become the inventors. Yeah, jointly collaborative AI and human can become the inventor or the applicant. Create new IP categories for AI. So IPR can do this thing. They can make us some one more part like this patents, design, copyright. So they make some one more part ki AI based patent. It may be new categorized. Whatever, if there are the 90% AI, 10% human, so it's come under the AI based patent, and there are some limitations in the AI based patent. Next, define clear ownership rules. So sometimes AI based outputs, AI based results is also still undefined. Like if any person make a code, if any person make a code through the AI, and that through that code he developed the one app, and through the app he is trying to do the business, trying to do the commercialized purpose. Now codes can be protected under the copyright. So if any person is completely create a code through the AI, so again question ki it is copyrighted. So because IPR don't recognize it is the generated for AI or not, है ना? But nowadays they are checking the plagiarism, so they find out कि it is 100% generated from the AI. So they give the FER report. FER, that means the first examination report. And then the examination report they mention कि your content, your code is completely generated through the AI, so we cannot register this. So either you resubmit your file or you can withdraw your file. So this time of the messages come. So it's better to do the remove some AI flag in any of the content, either code, either content, either images, any of the thing. Next, global alignment on an AIP laws, WIPO and other international community also discussion on the how AI can be regulate, how through the AI can be regulate the innovations. Ethical and responsible AI standards, through the ethics. If we talk about the ethics, so we should not use the AI in the academic, but if we don't use the AI, so how we innovate fast, because nowadays we should use the technology, and through the technology we should do the some fast work. So it should be if AI related any dispute, so it is resolution should be very fast in any different codes of the IPR. Okay, so thank you to all the participants. All the concepts is over here. Now, if any of the
Yes, sir. Yes, sir.
participant can ask any of the questions, so
Rovin sir, someone has asked a question.
yeah.
Question is, please elaborate on the process of copyright registration by individual for own work.
Okay, so there are very simple process. Whatever you create, either any image or any of the content, simply go in the IPR copyright site. There are the different site of the IPR copyright. IPR patent site is different and IPR copyright website is different. So go to the IPR copyright website, create your account, make your account, and simply submit your content in the PDF form. If you submit, when you submit, so you have to clear the article classification, like you are submitting a song or you are submitting an article, you are submitting a literature. So clearly you have to mention there what you are submitting. Another question, you are what you are submitting, it is already published or non-published, so you have to select the categorize. If it already published, then you have to do the one affidavit also. Already published content is by the your name only. If you have the jointly applicant, like two person published one thing and you want to take the copyright, so you have to take the NOC from the other applicant. And after select all the options forms, you just submit the your content, and the filing receipt is filing fee is only the 500. So it is registered within a 1 hour process, only 1 hour process. And after the submission, IPR will examine, and minimum 3-4 months to up to 1 year, they registered your copyright.
Another question that is being asked is, in FER, the person filing it gives the declaration of AI percent content, or the granting authority detects it.
Sir, repeat the question.
In FER, the
Okay.
person filing the document or whatever it is being filed should the person filing should give the declaration
If
of
you are
AI
asking,
content percentage
no,
or the granting authority.
No. Such type of clause is not there. Like you cannot declare you are creating the content from the AI. If any FER come, your content is highly AI plagiarized, and then they give the two option. One option,
That
you
means
can
the onus lies on the granting agency.
granting agency, because they give the two option always. After the FER, either you can withdraw your application or you can resubmit your application. So what's the FER raises, what's the issue raises, so you can resolve the issues and resubmit. Either you withdraw the application if you cannot revise as per the FER.
Okay, sir. Sir, another question that has been asked by what are the requirements for submitting the I you through document through IP account?
What are the requirements?
Yes, sir.
No, there are no any specific requirement. You just create your documents and you submit. In the requirement only in terms of the applicant details, your full name, address, email ID, sign, signature. Okay. You when you file on in patent or copyright, so you have to take the digital signature also, digital signature from the e-mudra. So that's is only one basic requirement. Another filing process is very simple.
Yes, another participant has asked the same question: is the certificate digital certificate by e-mudra necessary?
Yeah, it's very necessary because e-mudra is a good platform to provide the digital signature. If any other authorities, if you take the digital signature, so you can take, but e-mudra is a government recognized authority to provide the digital signature.
One more question, sir. Is it can somebody file their own patents or copyright, or is it necessary to go through a patent agent?
No, on anyone can file. Just there are the rules. Like if I file the patent, so I can file the patent with my name only, because when we create the account, so by default our name, full name is shown in the applicant list. So you can file with the own name. You can include some other person, but if you want to file the applicant's name where you don't want to include your name, so you cannot do this thing in your account.
Okay. Somebody has asked, can he or she prepare the patent application using GPT and then submit?
Yeah, definitely you can use the chat GPT, any of the AI tool, but always I say ki if you create or make any of the patent draft or design, but change that things. But at least 30-40% you have to change the manually.
And what are the charges of the registration for any design patent, approximate charges?
Government fees is 1,000 for the design patent.
Okay, sir. And for copyright, sir?
Copyright filing fees is 500 and the utility filing fees is the 1,600. This is the only government fees. You know, after the, if you make the design, if you make the design, you make the draft. So you create the account and submit with this fees, this nominal fees. But if you take the help from any other registered patent attorney agent, so there are the high fees because they make the design, they draft, they give the sureties. When FER come, so they sort out the FER also, so they take the high charge because it's a IPR is just like a court, you know. Like if you want to file a case, you just go to the court, you know. There are the Indian law कि any person can fight on case, but all the legal things you don't know. So how you will fight your case? Same in the IPR. Like if you create a patent, make a patent design, copyright and register, submit it in the IPR website. But when they ask the FER, there is the FER and they ask the some techno legal things. So technically, so you can defend, but legal thing you cannot defend. So that's why you need some patent attorneys.
Okay, sir. Okay, sir. Thank you, sir. I give my formal vote of thanks. Good evening, everyone. On behalf of the organizing committee of ATAL FDP, I propose the vote of thanks for this truly enlightening session on intellectual property rights. I extend my heartfelt gratitude to our esteemed guest speaker, Dr. Rovind Tiwari, for gracing us with this valuable presence and sharing such profound insights into the crucial world of IPR. Your session demystified complex concepts like patents, copyrights, and trademarks, and provided us with practical knowledge essential for innovation and research. And especially with the era of AI dawning, what are the current trends and what will be the future implications of using AI on these copyrights, patents, designs, and trademarks? Thank you for making this a very interactive and truly inspiring sessions. Thank you, sir.
Okay, thank you very much, sir, for inviting me. And definitely, it's a good session, and all the participants are also asked the questions. So that's so the participants are listening these things very patientfully.
Definitely, sir. Definitely.
Okay, sir. Thank you.
Thank you so much, sir. Thank you.
Okay.